the IRS can send you a notice for $10,000 and they can start collection activities without ever having to go to a judge and do all that. A new court case dropped and it's not necessarily taxpayer friendly. If you're filing these international forms, Form 5471 in particular, they come with high penalties associated with them. And taxpayers have been challenging these penalties over the last few years. The courts came out and have taken a position against court cases like Farhy, and in particular, this new one that just came out. I'm probably going to pronounce this wrong, but Safdieh is how I pronounce it. And it's specifically about the Form 5471 penalties. So in this video, we're going to talk through what are the penalties for Form 5471, what was the argument that these taxpayers took to get out of these penalties, and then how did the government react in both cases to reverse the taxpayer-friendly verdict that they came up with. Penalties associated with Form 5471 fall under Code Section 6038B, and there's a $10,000 penalty under that code section for not filing the form or if you file it substantially incomplete. Now, for the IRS to get that penalty, that's what these court cases are all about, is how does the IRS actually go about getting that penalty? Nobody's arguing that the penalty doesn't exist. They're talking about the administrative procedure of getting it. So basically, the way I like to think about it is, if I was going to say sue my neighbor for something, I think they owe me $10,000. The way that I would have to get that money from them, it's not like I could just go put a lien on their bank account because I said so. I would have to go to a judge, tell the judge what my complaint is, and then be awarded a judgment from that judge. I can't just go get the money, obviously. That's what makes the IRS different. They have special treatment on how they can obtain taxes from people and penalties. So when you pay your taxes or you file your tax return, it says you have a tax liability due. The IRS obviously doesn't have to go to a judge to obtain a judgment to get your taxes. If you don't pay them, it takes time, but they can automatically garnish wages. They can put liens on bank accounts. Now, that's for your taxes. For penalties, so failure to pay penalties, failure to file penalties, it's a similar thing. They're allowed to just send notices and start collection activities without ever going to a judge. They have that special treatment. The way they get there with penalties is under Section 6671. Section 6671 essentially says that penalties are assessable and administratively collectible as if they were taxes. So when you file your tax return that says you owe $1,000, but you pay it late and there's a $100 penalty, that penalty is assessable the same way taxes are, and they can just collect it and they can start collection activities if you refuse to pay. Now, the international forms like Form 5471, that Section 6671 is under a special section of the tax code. It's under subchapter B, which deals with all of your domestic tax and penalty section. The 5471 with Section 6038B is under subchapter J. It doesn't cover subchapter J. So with the 5471 penalties, they have to put in that code section that these penalties are assessable as if they were taxes, because Section 6671 doesn't cover them. And that's what this whole argument is about at the end of the day, is the taxpayer saying, these are not assessable penalties. So if you want to charge me $10,000, you have to go to a judge, get a judgment, and then you can start collection activities. And if you're thinking about this realistically, there's almost no way the IRS would be able to go through that process of getting a judge to get a judgment to collect the penalty. So the argument comes down to what was the intent at the end of the day. So in Farhy and Safdieh, in both cases, the tax court and the taxpayer said that the wording for assessable was not in Section 6038B. Therefore, the court did not have the ability to collect those taxes. And the tax court sided with the taxpayer in both of those cases. So everybody started thinking, okay, now we're safe on 5471 penalties. We don't need to go back and file in some cases. They can't actually collect this tax. We're good. Problem is, the IRS came back and appealed, of course. IRS won Farhy, and now they've won Safdieh. What the IRS argued was, they pretty much agreed that there's a gap, but that what they didn't agree on was the intent, because that could get out of hand in a way. The IRS argument was that Clearly, they meant for it to be assessable because the whole point of the 5471 penalties was that they wanted there to be an efficient way to assess penalties on people who didn't file the correct form on time and substantially complete. The taxpayers' argument was that they intentionally left the international penalties outside of the assessable penalty section because they knew that it was outside, so it had to have been intentional. They didn't want it to be that easy for them to collect the penalties on international forms. Essentially, the courts sided with the IRS to really look at their argument for the intent of the provision itself and basically said that the idea was clearly for them to be able to assess these penalties. We agree, although they didn't actually say that they agree that there's a gap in the way that it was written, but they didn't address the gap itself other than to say, yeah, clearly we expected them to be able to assess the penalties. Otherwise, there'd be no way we could assess the penalties. So they are assessable. So at the end of the day, we're back in assessable penalty world where what this really means for you practically is if you don't file your 5471, the IRS can send you a notice for $10,000 and they can start collection activities without ever having to go to a judge and do all that. What I've seen in practice is that if you're filing a 1120 or a 1065, so 1120 for a corporation, 1065 for a partnership, and you have these 5471s, if you file those forms late, the IRS is automatically sending you the notices for 5471. So it's something you're going to have to deal with. And you really don't have a Farhy type argument anymore to say that they're not assessable penalties. If you're an individual filing 5471, I personally haven't seen automatic penalties on the 5471. I have talked to practitioners who have seen that, but there's a risk, and it's something that we have to deal with. And now we've just lost one of the bigger arguments to say that the IRS can't collect those penalties in the first place. So if you're dealing with Form 5471, it's something you really need to get done correctly. And if you're missing prior years, we can go through things like streamlined procedures. They do have programs to get back into compliance with the IRS if you're dealing with delinquent forms in the past. But the important thing here is that these arguments, if you're reading it online, that the IRS can't collect these $10,000 penalties, unfortunately, as of now, the IRS has won the appeals for these. So you got to get these 5471s done correctly and on time in order to avoid these $10,000 penalties. If you need help with your Form 5471s, or if you have questions on how to file for foreign corporations, reach out to us at McGowanTax.com. We'd be happy to help you with your situation.